We're really happy to have for our last session of Supreme Court Day two very distinguished reporters, and thank you both for being here. Andrew Chung from Reuters, who is just going to talk a little bit about the Pulitzer Prize-winning series that he was involved in on qualified immunity, which isn't exactly a Supreme Court case, but obviously very relevant. And I also want to welcome Richard Wolff, who has covered the court for a long time for USA Today, recently retired. So he's now in a position to tell you all the scoops that you ought to go for. And he doesn't have any, doesn't have any competition. So you can hit him up for all your advice and get some good stories. So let me start by turning it over to you, Andrew, to talk a little bit about, your series, how you got the story, and then we'll shift into the Supreme Court. The reporters were at the court earlier today, so
okay.
we'll shift over to that and then take lots of questions.
Okay. Hi, everyone. I'm Andrew with Reuters. I've been covering the Supreme Court for about 6 years, so I'm actually one of the least experienced Supreme Court reporters on the beat. There are a lot of much more seasoned people in the press corps at the Supreme Court. Like Rich was retired, but there are people who've been covering it for decades. So this project actually was something that it was sparked by some cases back in 2017 and 2018 when the court denied reviewing a case involving police shooting a young man in the back in Texas. And there were some other cases as well. And we were kind of thinking, well, how important is this doctrine that is protecting police in all of these cases, this doctrine called qualified immunity? And there was some debate between the justices, specifically Sotomayor and Alito, about that doctrine. And she was saying in a couple of different opinions that it was shielding police in a way that was making them think they can shoot first and think later. And Alito was pushing back on what she was saying. So we wanted to sort of test her hypothesis. And so it took a very long time. It was a data-driven project. We read thousands of appellate and district court rulings and also looked at Supreme Court data itself. And we found that this doctrine, qualified immunity, was increasing in its force and power in lower courts. And this was all based on the Supreme Court over decades guiding and strengthening this this protection. And we wanted to focus it on something in particular. So we focused it on police use of force and allegations of when they use excessive force. And so we had to create a database. We had to analyze our findings, and we produced 4 different main stories and narratives out in the project, as well as some other stuff. So I'm happy to talk more about like how the Supreme Court works on a daily basis, or about this. Happy to answer any of your questions, but maybe Rich wants to chat a little bit about his time there.
Let me just jump in. As Sunny said, I'm retired, so I can say anything I want at this point. I was not a veteran on the beat, actually, because I only covered the Supreme Court for about 10 years, which is nothing compared to some of the people, Nina Totenberg, some of the folks who have been there for decades. Bob Barnes at the Washington Post has covered the Supreme Court, I think, now for about 25 or 30 years. Adam Liptak's been there for a long time. Before him, Linda Greenhouse was there for a ton of time at the New York Times. So it is a beat that people don't relinquish for obvious or maybe not so obvious reasons. It's a wonderful beat. In my case, it was my last beat. I had covered Congress and the White House since moving down from New York in the 1980s. So in that sense, like a lot of you, I was a regional journalist for about 10 years of my career. Got the opportunity to come down here covering literally, like local congressional delegations, and then went from there. And so I did Congress for about a decade. I did the White House for about 5 years. It's pretty easy to burn out on the White House beat. And some other things in between, including becoming an editor and realizing I hated being an editor and going back to writing. And I didn't join the Supreme Court beat until I was 58. One thing I wanted to say is that there's no one way to become a Supreme Court reporter, or more broadly to cover federal courts in DC, if that's one of your goals. You would think that you'd have to have a law degree, or you would think that you'd want to have a law degree. Not the case. I'd say, check me on this, I'd say maybe roughly half the reporters who cover the court regularly probably have law degrees, and about half don't. And I don't see the difference in quality really between, I can sense sometimes that someone with a full law degree might understand the ins and outs, the reasoning of a case and why a case was decided the way it was a little bit better than someone like me, who my closest thing to law school was when I got the beat. My daughter was in law school, so we would trade stories back and forth. But I think that actually there's an advantage to having the background I did, which was basically I'd covered the other two branches for combined almost 20 years, and so I brought that kind of policy knowledge and knowledge of different issues in Washington that were obviously going to come before the court. And I really didn't find that I missed having a law degree at all. So my point there is simply that there's no one way to aspire or to come to this beat. But you should learn the law as best as possible, whether that's a law degree or whether that's just auditing some classes, constitutional law class, something like that, I think is a great idea. Because there are rules to the law that there are not, obviously, in the area of politics. Some of the justices, some of the conservative justices in particular, kind of like to think of themselves as locked in by what's the precedent, what does the Constitution say, what does the federal law say, and there's the answer. And even though that always, or almost always, tends to be a conservative answer, they feel like they can justify it by virtue of, well, here's all we're allowed to look at. We're not actually allowed to register our own opinion. That said, I think it's obvious that the court is more political now than it ever was, but it's on both sides. So you have several of the conservative justices who are more conservative than their predecessors. Obvious ones like Amy Coney Barrett replacing Ruth Bader Ginsburg is a complete flip, just like it was 30 years ago when Clarence Thomas replaced Thurgood Marshall. But other cases, even on the liberal side, and people don't talk about this as much, probably each of the three liberals on the court are more liberal than the people they replaced on the court, just as several of the conservatives are more conservative. So I think there's a lot of misgivings is the wrong word, misimpressions about the court. The whole debate about the court's legitimacy is a legitimate one, but it's not only on the conservative side that needs to be assessed. I think if there were 6 liberals instead of 3, I think you'd hear a lot less squawking from the liberal side about the court's legitimacy, and you'd hear a lot more from the conservative side. So just as is the case in politics on the Hill or at the White House, take those kinds of arguments with a grain of salt. And one other thing I'd just say about the beat is the biggest thing that happened in the last year was probably the leak of the Alito draft on abortion. That never happens. When I came to the beat, I had been most of my career chasing other reporters, trying to get scoops, staying up late, working sources, et cetera. And when I came to the beat, I said, now I got to get to know 36 law clerks or 38 law clerks, whatever the number is. And the answer I always heard was, well, why bother? They're never going to tell you anything. They'd be disbarred if they said anything. And it became a beat, unlike my others, where you really didn't have to, constantly befriend people trying to get scoops. There weren't any. And so you could really treat it as more of a cerebral beat and just cover the cases and cover, the docket and cover the justices. And this scoop by Politico this year, I think, changes that to some degree. And now, who knows who talked and there's any number of theories. But now I think you're going to see more of that type of reporting from this beat. I think reporters have gotten a little bit sanguine about, well, I'm never going to get scooped at the Supreme Court because we all cover the same stuff in the same amount of time. The way you shine as a Supreme Court reporter is by coming up with better ideas and better enterprise. And I think that that's probably going to change a little bit now, and it'll become a little bit more like some of the other beats in town where you never know who might scoop you. So you better be careful and work whatever sources you possibly can, because who knows when the next case is going to be leaked. That said, it could be that another case won't be leaked for another few decades because it's just such an unusual thing. But I do think that that's, we were just talking about the New York Times is hiring a second Supreme Court reporter. It's a very exclusive beat, other than Reuters to some degree when you were there with Lawrence Hurley, or AP, the Wall Street Journal, kind of, because Wall Street Journal had a reporter and Dow Jones had a reporter, but mostly it's one reporter per news outlet, and only about 20 regulars, meaning Supreme Court reporters with hard passes, who get the best seats, who get the best treatment from the press office, et cetera. It's a very exclusive club, but I think maybe we're going to see it broaden a little bit. Obviously, since it's become more and more politicized, it's more of a general readership beat as opposed to, for just for legal nerds. And I think, the Times hiring a second is probably going to lead to the Post hiring a second, and you can see where that's headed. And I think the leak of the abortion case probably has at least a little bit to do with that. So I'll shut up, and I'm happy to take questions.
Before we open it up for questions, Andrew, I just wanted to ask you to give your thoughts about how to be awesome on the beat. Or you have any tips to start off with?
So I think that I think it's true that you don't have to have a law degree to cover the court, but especially if you're going to work for a wire service, and I think it's newspapers and other digital organizations, they're all changing to be faster. And it's like on a wire service like Reuters or Bloomberg, you got to be extremely fast. And so you don't have to have a law degree, but I think if you're going to cover the court, you need to understand a few basics of procedural law, especially, but also substantive law. And so the suggestion to take some sort of even some basic classes on that would be really good, would be really helpful, because when, for example, when you get a ruling, you have to, first of all, you have to be extremely prepared for all of the options that could result. And once you have that down, you look at typically the top of the ruling is a synopsis, and you're trying to figure out through the disposition of the case and what was held by the court in the case, you need to put out a news alert immediately. So to do that and to do it quickly requires a little bit of procedural and substantive knowledge. But to do the job well, I think you got to be prepared to be working a lot. The court actually does a lot of work because it receives, I think, something like 7,000 petitions every year. Of course, it only takes up about 70
1%.
of those. Yeah, but those. The rulings from those 70 cases are part of the caseload, and they can themselves just make up a lot of work. But of the other 6,900 and some petitions that are filed, you're going to also be doing a lot of stories about them, especially the ones that are denied, the important cases. So with each of the cases that you're doing, these are legal issues that have been percolating through the lower courts for some time already, and so each one requires quite a bit of preparation. So generally the basics of the Supreme Court, aside from the intrigue on the inside and the leaks that are the potential for future leaks and the politicization that we're seeing a little bit more and more of by through some of the speeches that the justices are giving, some of the debate that's happening in public on the legitimacy side. That, aside from that, in terms of like the substantive legal work of the court, you've got the orders that are weekly, pretty much, and then you have rulings, which I talked about already, and then you have something else that has gained a lot of momentum in recent years, which most people refer to as the shadow docket. And these are emergency requests by certain parties that lost in lower courts to basically maintain the status quo, to sort of prevent being, quote unquote, injured by whatever the dispute is about. And that has really gained in prominence at the court, and it takes up a lot of our time now compared to even just 5 years ago. It really sort of ramped up during the Trump administration, and it's continuing now. They just issued an order today in a shadow docket case about a January 6th investigation issue. So,
Just quickly to follow up what Andrew's saying about being fast, and obviously that applies to any beat these days. There's a lot of pre-writing that goes on, probably more pre-writing than I had on any of the other beats I've covered, where you're trying to cover yourself because you have zero story and then you have 100% of the story a minute later. And so, I had nothing, but now I have 87 pages, and the bottom line is they ruled this way or that. And you got to have the story written already, usually 2 different ways or even more than 2 different ways. But the lesson I wanted to convey, and a lot of you I'm sure know this story, when I came on the beat, it was in time to cover the 3-day Affordable Health Care Act extravaganza in 2012. Unlike any other case that they had heard, certainly up to now, where they're starting to have longer oral arguments, kind of in a post-COVID world. Back then, they scheduled 6 hours of argument for that case over the course of 3 days. Usually a case is 1 hour. Anyway, and correct me if I get this a little bit wrong, when the decision came out, which was a John Roberts decision to uphold the Affordable Care Act, he starts reading inside court. When you're inside court, you have a pencil and a piece of paper. You don't have any recording equipment. You have no way of telling anybody what you're hearing, which unfortunately these days has most of us who have covered the court not go into the courtroom when the case is being decided. You're listening to a squawk box near the press room. But anyway, he starts to announce the decision of the case. And at first he's talking about why the Commerce Clause doesn't apply, and that's not a reason for the Affordable Care Act to be upheld, at which point several of the runners, they're kind of called runners for the networks, go racing down the steps to their reporters who are standing there informing them it's going down. Roberts has, knocked down the Affordable Care Act, which was 100% wrong. So understanding in this case that there were going to be about 3 different ways that he could uphold it, and he ended up upholding it based on tax law, would have been a smart thing. But I think it was, and this is why I said, correct me if I'm wrong, I think it was maybe Fox and or CNN
got it wrong.
Who got it wrong at first and had to.
But Reuters got it right. I wasn't there, but Reuters got it right.
We got it right. USA Today got it right as well. So just a.
That's an example where, I didn't cover that, but it's an example again of like if you are honed on how to read a Supreme Court ruling, then it's harder to get that wrong. Like if you're,
One thing to do in this case, although in this case it was multiple rulings with mix-ups in the number of justices who were on which side. Justices Kagan and Breyer kind of cut a deal with the conservatives to rule this way on Medicaid if they could get Roberts to rule that way on, which was a scoop that took years for Joan Biskupik, one of my predecessors on the beat at USA Today, who went on to a couple of other places and ended it as now at CNN. She was among those to first break the news on how that came to be. But what you can do is, what I was thinking as you said that, is go quickly in the synopsis of the case to who ruled which way. and you'll see, oh, well, all the conservatives are here and all the liberals are here. So that's an indication that, I mean, that's not the end of your research, but that's a quick way to say, oh, now I get it. And then you can work your way back to other parts of the summation of the case before you, it's going to be an hour or more before you actually can get the time to start reading what the justices themselves wrote.
Yeah, I mean, it can be, it's intellectually challenging and also very stressful at times like that. So, yeah.
Okay, since none of you were on the beat yet, I want you to feel free to ask questions, not just about the Supreme Court, but also about other illegally involved cases that you think you might be called to cover or that are relevant to your beat, because I think these journalists can give you some tips on how to do it all better.
Hi, I'm Suzanne. I'm with Roll Call. I was wondering what your thoughts were on all of the live streaming, both at the Supreme Court, but also at, even some of the federal district courts were offering it during COVID. I found in a way I almost found it easier than covering hearings in person because I could have my recorder on and well, depending on the rules, you're not supposed to, but, or you could take notes more easily, whatever. But then also I didn't get to cover that much in person, just having been shut down for half of the time I've spent out of college. So I was just curious, what do you guys prefer covering in person? Do you think the live stream makes it easier? What do you think is the better way to do it?
Actually, it's a great question because the journalists in the press corps currently, a lot of people sort of refer to it as a bit of a curse because it is actually really nice to cover a Supreme Court case from the courtroom itself. I mean, it's interesting. It's neat to be there. You can and it's good to be able to see the justices, their facial expressions, their mannerisms, what's going on, and also you can monitor what else is going on in the courtroom. But with the live audio streaming, it is a bit of a curse because, especially for big cases, covering it just by listening at your laptop makes it faster, and especially when you want to report to the public the way the justices are leaning in a specific argument, that it's easier to do that through the live audio. So it makes more sense to actually sit at your laptop, rather than being in the courtroom, which is where we would rather be. So, I mean, I think a lot of the news orgs are kind of navigating that. Somebody's upstairs in the courtroom, somebody's down listening, putting out news alerts if needed on a big case like affirmative action recently. And I mean, I prefer for there to be more access in general. So, I mean, I think that there should be live video of the court, not just audio. But it's a pretty slow-moving institution in terms of adapting or adopting new technologies, and they have their reasons for it, I think. But it took a very long time just to do audio. It took the pandemic to prompt that.
And there was an open question about whether Roberts would even keep it once they were back in the courtroom, because as I mentioned, there is a little audio box in the press office, which is adjacent to the press room, that we could listen to if you chose not to go upstairs because perhaps you work for a wire service and you just need to be quick. And the New York Times might be thinking, or USA Today might be thinking, I don't have to be as quick. I'd rather get all the nuance and be a few minutes behind. Right. But when they went back into the courtroom, was it this year or was it for part of last year?
Part of last year, yeah.
Roberts maintained, a lot of pressure was on Roberts to maintain the audio streaming. So now that seems to be a permanent facet of the court. And I think it's a wonderful thing from the public's point of view, because it's not just us who can listen to it, it's anybody. I have to constantly remind relatives who, I don't think most people understand, hey, they're about to, have 2 or 3 hours of oral debate on the abortion case, and I can listen live, from anywhere in the country. So I think that's wonderful. From a journalism standpoint, I kind of agree. I'd much rather be in court all the time watching for a lot of the nuance, the interaction between justices. If you're a junior justice, if you're not one of the senior justices, you're going to speak up last or close to last in conference. So what you're doing during the oral argument is you're trying to sway your more senior colleagues to your point of view by virtue of the questions you ask and the points that you allow the lawyer on your side to make. There's a lot of that kind of stuff going on, and it's nice to be able to pick up on it for purposes of the article that you're going to write at the end of the day, not so much what you're going to churn out in the first 5 minutes. So kind of a mixed bag, I think.
Thanks.
You mentioned that it's easier to not make mistakes if you know how to read a Supreme Court decision. So what are your tips for us on how to read a Supreme Court decision? Should we, have to do that?
So they can be inordinately complicated, that's for sure. So I would make the synopsis your friend, which is the top of the opinion is always the synopsis, and you've got some key elements of the synopsis are the held part of the synopsis, where the court is saying what it has held in this case. And so if you're, when I say being prepared for the for the outcome, just like what questions were actually presented in the case, and there could be more than one. And in general, the court is going to answer those questions in that section. And so if you pair that with the disposition of the case, which is at the very end of the synopsis, you can find the disposition, and that is where they are either reversing the lower court or affirming it or vacating. They could be doing something more complicated, like affirming part of it, reversing part of it. I'm not saying that this is like some sort of science. It's just, these are the elements of an opinion that if you're working to get something out quickly, along with being prepared for it, you could take the held section and the disposition and get a pretty good idea of what's going on.
And then if you go, especially if you're looking for, a couple of pithy, quick quotes, almost, well, I won't say almost all the justices, but a lot of the justices will sort of sum up in the last either paragraph or two or page or two of their opinion. So that applies not just to the opinion of the court written by one justice, but concurrent opinions written by those who agree, and then in particular the main dissent. You can, after doing what Andrew suggested, you can go, I usually go straight to the back and look for, a Justice Kagan or, one of the great writers on the court to kind of try to hit a home run with that last paragraph or two. One other thing I'd say about the synopsis is it's written by court staff, and they will say, thus and such about this portion of the case, and near the end of that, or at the end of that section, they'll say pages 4 through 16, and like that. And so if you're interested, or what you're interested in, you'll quickly, because sometimes it'll be like, summing up all the action of the lower courts, pages 2 through 22, and it's like, well, I don't need any of that, so I can ignore that till much later in the day, if at all. So there are little tricks like that that kind of direct you to portions of the actual opinions, if you have time to go beyond the synopsis to the opinions when you're first writing. And then, but again, almost always at the end of each opinion, the concurrences, the dissent, you'll find some sort of summing up.
Hi, I'm Candace. I work for the 19th. And I wanted to kind of ask, rather than about the looking at the opinions themselves and writing stories, like what you were talking about as far as preparing beforehand and pre-writing. Now that I'm asking this question, I realize it might be hard to talk about this in a general sense. So if there's like a specific case that you wrote about recently, maybe that might help. But I guess I'm curious, like what kind of information you can include in a pre-write, you know, because I'm more familiar with doing pre-writes in an election sense, which seems more straightforward to me than like all of this like legal stuff and analysis and things like that that could go into an opinion. So I guess I'm curious at like how you go about doing that.
Yeah. Oh, go ahead.
Well, it's been a couple of years since I've done it, since I retired at the beginning of last year. But you know, there's a certain formula to it. I think I mentioned before, there can be more than two ways a decision comes out. It's not always yes or no. It's a lot of in between. But let's just say it's yes or no. Let's just say abortion is good or bad. Affirmative action is upheld or not. You write two leads. All sorts of obviously internal things in the publishing system that you need to be careful with so that somebody doesn't hit publish. And you know, you have your two different options for a lead. If you're, what I would usually do is try to write a second and a third graph that would follow those two options, or maybe I've actually written three options, and I'll go 2 or 3 paragraphs deep. But you don't want to go too far because, you know, you're going to write 3 different things. It's going to take a lot of your time as a reporter to do this, and it would be better to be, or ideally it would be better to be out reporting something new. But then you're going to fill it in with all the relevant background, and you know that can almost be pulled from a prior story, at least to begin with. I always found in my case, and I think it's true of others, that the quality of your first online story is going to look okay to the reader, but you know that you've basically stolen a lot of your information from your own prior stories. You've backfilled to have 10 or 12 or 15 inches. I certainly don't mean stolen from somebody else, but you've used paragraphs of background, you know, what happened in the lower courts, why this is important. You're just putting that into the pre-write so that something can get out the door fast. I know the wires don't bother as much with all of that background because I think in your case, get the lead out or get 2 paragraphs out. And that's, so you can do it that way as well. I generally flushed out about a 10 or 12 inch story with all the relevant background, and I'd have 2 or 3 versions of that, you know, depending on how the case might come out, hoping that one of my versions is indeed the way the case came out. And then you also can have, you know, flagged for yourself, depending on how your publishing system works. Here's where I would put a quote from the opinion of the court. Here's where I would insert a quote from the dissent so that you can quickly fill in the blanks. So it's pretty formulaic in that sense.
Yeah, I mean, we do it similarly. We do, I mean, I've had pre-writes where I've had like 8 different potential options that the court might do. And, you know, I mean, there's obviously a lot of time spent that's not gonna go anywhere. You're planning
Right.
for all these options and thinking about them and thinking how it could come out, and it never comes out that way anyway. But, you know, especially when you need to get something out fast, you hopefully have gamed out all of the outcomes that are possible, and one of them is what works. But, you know, sometimes like a decision could be very mystifying. You know, like despite what I was just saying about the synopsis and everything else, it can still be, well, okay, well, what is going on here? And so, I mean, it also helps to have something prepared that's a little bit more general to put something out quickly, at least giving the public an idea of, you know, at least the top line thing they have done, even if you don't get too specific yet. You know, you give yourself like a few more minutes to digest what's going on. But in terms of the background, yeah, we do the same thing. We have all of that prepared, and at least for us at Reuters, we put out rolling updates. We put out a couple of paragraphs, then a couple more paragraphs, and a couple more paragraphs, and then eventually we have a full story. So,
You know, we didn't mention before, but, and you guys probably mostly know this, but if there are 70 merits case opinions or cases coming before the court, cases they're going to hear oral argument on. Probably 50 of them are boring as heck to the general public, and we're barely going to write about them. Or at least, the major papers and networks are barely going to write about them. I think the Wire's probably write a few more than that, but short. There might be a handful of great cases. There might be a dozen pretty interesting cases behind that handful. And then there's going to be a case about, ERISA or, just something that nobody understands, patents. And we follow them. We follow them for court trends. We follow them for alignments of justices who voted with who, peculiar little dissents for whatever reason. There's always something to write about or to file away for a future story. So they're worth us covering. But I'd say out of 70 cases, I might, write 20 of them and not write the other 50. The other thing that should be said, for the cases that are important and that we do cover, again, like any other beat, there's different phases of the case. So my favorite is before the case even gets heard, because then it's open season for enterprise stories. And back in the day, I could travel and go places that are relevant. I could interview plaintiffs. I could interview people who would be affected by this decision, et cetera. So any kind of enterprise that you can think about that's relevant is usually to be written before the oral argument. Then there's the oral argument itself, which you cover, which is the most fun part of the beat, but probably the least interesting story to write, because every story hinges on a verb that's something like, they appeared to be this, or they seemed to be that, or right? Those are the two words more than anything else, because you don't know. You listen to an oral argument and you're trying to direct the reader, but you can't, overemphasize that you really don't know how it's going to come out yet. So you just enjoyed the oral argument, but it's pretty hard to get good coverage on that story. And then obviously there's the decision, which can often be 3, 4, 5, 6 months later.
I have one more question, and it was about the enterprise stories. I guess, you all highlighted a story earlier, and I'd like to hear another one that you may have worked on, or even other Supreme Court reporters that you thought was good. I'm just trying to get a sense of what enterprise Supreme Court related enterprise stories look like.
Well, hopefully they come from the work that you're doing every day. Like this one, this idea was sparked by my having covered a couple of, these were tragic cases, but not cases that everyone was paying attention to. Like the one in 2017 was about, a young man who was shot in the back and paralyzed by a police officer. And, the police officer was protected from any kind of liability because of this doctrine. And so, we covered that just because it was interesting and seemed important, but then it obviously became much bigger. It's just like any other beat in the sense of, for example, the court just decided a really big gun case, expanding the constitutional right to carry a gun in public, or recognizing that right for the first time. So that's a landmark case. So of course we wanted to focus on it a bit. So, I did a couple of different stories in the first iteration of what became that ruling. Just from talking to people involved in the case, you can find great stories. Like, in that first iteration, there was one of the challengers to this case was about a New York gun law. So one of the challengers was he's before the Supreme Court trying to challenge a law about New York's gun restrictions, and that case was about transport licenses. Well, it turns out that he had just had his own license, his own firearm license, suspended and all of his guns confiscated, which nobody knew about. So just by finding people, asking them what's going on, you can come up with a great story. in the second iteration of that case, I called up the judge, the state judge in Troy, New York, whose ruling or whose decisions related to 2 gun owners led to the latest iteration of the case. And, not thinking that he would talk to me, because most judges, don't really want to talk to the media, but he did. And he was talkative enough that I actually rented a car and drove to Troy and talked to him in his chambers that very day, just to in case he got cold feet. I just wanted to go grab him as soon as possible, and that turned out to be an interesting story because nobody else had that either. And so, you can find stories kind of. I think if you just start digging into who's bringing the cases, who else is involved in the cases, there's always a neat things to talk about.
I think there's who stories, and then there's what stories as well. One summer, summers are kind of your time off on the Supreme Court beat, in the sense that the court goes in October and finishes up in June. And one summer, our main Justice Department reporter and I combined on a series on the death penalty. The main reason being that in a case that had come before the court involving a death penalty case, Justice Breyer, who just retired, wrote in a dissent, kind of in an aside to his dissent, that, gee whiz, I think it's time that we take up a death penalty case based on, is the death penalty still constitutional or not? And Justice Ginsburg agreed with him that was worthy of taking it up. So in a sense, you had 2 out of 9 justices on the Supreme Court kind of broadly hinting that if given the opportunity, they would say the death penalty is unconstitutional and we shouldn't have it in the United States anymore. So we thought that was interesting enough to, just take it upon ourselves to do kind of all angles on the death penalty. Another example of enterprise, one summer I spent most of the summer doing a series of stories on John Roberts at 10 years. So those are obvious stories, 10 years, 20 years, 30 years, whenever, you're doing some sort of a update on somebody's career or something. I wanted to do a piece on the Roberts Court at 10 years, which I spent most of the summer doing, thinking everyone else on the beat was also doing it. And it turned out no one else on the beat was doing it. I don't know why, but, we thought it was a pretty nice piece when it ran. A who story that I did, that I enjoyed, and it was really a feature, was the names behind famous cases and going back to those people or their next of kin, how cases get to be, how one person gets to be famous, like whether it's Gideon or Miranda or whatever. And we did sort of a kind of a breakdown on, I think it was 5 or 6 or 7 famous cases and stories, the story behind the person whose name was, became famous as a result of the case. So again, as Andrew said, like any other beat, I think there's who stories, there's what stories, there's where stories. Back in 2013, when we were leading up to the John Roberts decision on voting rights, the notorious John Roberts decision on voting rights to many, most of us on the beat who don't get to travel that much compared, say, to other beats I've had, were down in Mississippi beforehand. I actually went to Alabama to do a different story because I knew everybody else would go to Mississippi, which is where that case was from. No, the case was from Alabama, yeah. And I went and did a piece from Mississippi. But again, it's kind of a typical angle, to go down beforehand and do some on-the-ground reporting about the conditions that led to that kind of a case and ultimately a decision striking down the guts of the Voting Rights Act. So, and that's really what I enjoyed most about the beat, were those kinds of enterprise stories.
I think inevitably, when you're covering all these cases closely, threads will emerge. I mean, this is in any other beat, right? Like this term, for example, there are 3 cases that are they are about race, essentially. One is, everybody knows about affirmative action, but there's also a case about federal, like congressional redistricting, also from Alabama, and it is similar to affirmative action in that the challengers are saying that there was too much race injected into the process, that certain groups, Black Americans, were given preference in this redistricting process, same as in the admissions process. And there's also a third case this term involving the Indian Child Welfare Act, in which the challengers are also saying that it's unconstitutional because race is part of this process that gives preference to Native American families. So that is that's a common theme. There's a common denominator among all of those cases, and so that's that's an example. A couple of years ago, right around the 2020 election, there were a few justices that actually said something about this doctrine that was quite obscure at the time, called the Independent State Legislature Doctrine, which seeks to essentially immunize legislatures from any kind of second guessing by state courts on voting rules or procedures and redistricting. And so we wrote a story about that, went to Iowa to create sort of like, to have a narrative related to the story. And now the court is actually taking it up, is going to be hearing that case, or hearing a case about that to decide that issue next month. So you're just going to spot those sort of trends or interesting threads, and you can run with them.
One thing I would say before I forget about coming to DC, whether you're a reporter or you're an editor or you're a bureau chief or whatever, is it's worth keeping an eye on the Supreme Court docket. Because it's easy to forget about it and leave it to your entity's one Supreme Court reporter, wherever you're getting it, whether you're getting it from the AP or from your own, or from Reuters or from your own, because there's endless possibilities based on where a case came from, meaning what state, what appeals court, what trial court, or what subject matter is involved or who is involved, to get one of your own reporters onto a story. You coordinate obviously with the Supreme Court reporter, but working for USA Today, which kind of gradually became more and more the USA Today network because we kept downsizing, but we had umpteen newspapers around the country. I would use and I would invite reporters from Kentucky in this case, or Arizona in that case, or whatever, to get involved, to write beforehand, to do enterprise beforehand, to come to Washington. And if you can get the press office to say that we have room for you to come in, and I would usually try to give them my good seat, and I'd take their terrible seat behind a curtain where you couldn't tell who's speaking, unless you recognize the voices, because I think it's a great opportunity. Again, it's an exclusive beat, and I don't mean that in terms of you have to be good at it. What I mean is there aren't many of us. And getting your reporters, correspondents, editors to the court when it's relevant to them, because it's a healthcare case, or because it came from New York, or because it involves so-and-so, is a good thing. But it's easy to miss if you're just assuming that someone on the justice team or the legal team or the Supreme Court team is going to alert you. It was kind of my job to think of, alerting the points, as we called them. The whole same-sex marriage case came out of the Sixth Circuit, and so that was relevant to Michigan, I may get this wrong, Michigan, Ohio, Tennessee, and Kentucky. And Gannett, I think, has the largest, or almost the largest paper in each of all four of those states. Maybe not Ohio, we have Cincinnati and some others, but, Des Moines, not Iowa, Ohio. So this was, the Sixth Circuit is Michigan, Ohio, Kentucky, Tennessee. So I went out of my way to make sure that those papers were involved, and it turned me from a bureau of one to a bureau of five. So it's mutually beneficial.
You talked about the issue of sourcing clerks. How have you sourced from this beat effectively? Where have you found like the best sources?
What I said before, which is somewhat true, but also somewhat unfortunate, right? Because we're all journalists and you want to scoop the other guy all the time, is that it's a very different beat. I don't know that this is the case with all court beats going down to, local courts. But the rule of thumb, when I came on the beat in 2012 and when I left it at the end of 2020, was, you're not going to get the principals to talk. I met and had FaceTime with and had coffee with virtually every justice, but almost always off the record. Never really met more than a handful of clerks in passing, just kind of bumping into them at an event or something. Never really tried, and this is the unfortunate part, to, get people inside the court to tell me things that they shouldn't tell me, which is the whole nature of covering the White House or Congress, because the bottom line was they weren't going to. And as I said, until this, little earthquake with the abortion case, it never happened. So what was your percentage? We talked about how much time is involved in doing pre-writes that will never get written. Well, how much time is involved in, buying drinks for people who will never tell you anything? So, so that's where it comes to scoops, like literally flat out, I have this story and no one else knew it because somebody told me something or gave me a document that they shouldn't have. But in terms of the more general sourcing on the beat, there are staff at the court who can be helpful. There are experts in any field at law schools. There are people at the Solicitor General's office, often called the 10th Justice. This is who argues before the court for the current administration. There are all of the scores of people who have done that in the past, worked at the Solicitor General's office or in the Department of Justice. So umpteen legal experts, you just heard from one before us, but very few people who are in a position to know something and leak it to you and to no one else. I mean, I never came across that in my 10 years on the court. I don't know what you think.
Former clerks are a good source also.
Former
Good-
clerks
like
are
a good
great.
body of sources.
Yeah, that's true. Former clerks are great, more so for I'm profiling so-and-so, and you clerked for him 3 years ago. Not so much for, particularly, I think the case is that they shouldn't tell you things from their year, even after that year is gone. They're not supposed to tell you anything inside. Not that they won't maybe on occasion in this case, but you clerked for Justice so-and-so in the famous year of 1997 when, tell me the inside stuff from that. They're not even supposed to tell you now.
In general, it's much different than any other beat I've had, and for all those reasons, it's very, very cloistered, very lacking in transparency. So it's hard to pierce the veil, or the many veils of the Supreme Court, but you do what you can.
Do you guys think we'll find out who leaked the document?
One interesting thing about that is we don't know whether they know by now. They had this internal investigation.
Yeah, there's apparently, I think the court has its own communications about it, but in terms of a report that allegedly will surface at some point, like we have no knowledge about that. We ask. So the weather is based on comments that certain justices have made, so we think there will be. I have no personal knowledge of that, and as for when, that's what I ask about, and that's what I don't know.
What are your theories on it?
Well, there are two main theories.
Yeah, I'm not gonna.
I mean, the obvious ones are the first obvious one was the liberal theory. The liberals are pissed off about this upcoming ruling, and so they're going to leak it to the press. And so a liberal clerk, that was the first thought. And then the second thought was, wait a minute, this is more Machiavellian than that. It's a conservative clerk who's trying to lock in Kavanaugh or lock in another justice who might be, maybe Barrett or whatever. We have our votes. We don't want to lose them. Let's leak this out now, and then they'd be embarrassed to change. So those are the two obvious ones. But, just as we were saying with the Supreme Court decision, you can often have, they voted this way or that way. There's in between ways. And so there's probably more possibilities than I can even think of.
Yeah. Could be just someone else.
But piggybacking off of that, it sounds like you both maybe think we'll find out if they know without actually. It's more likely that we find out that they know, that they might have an idea who it is without us knowing. Is that possible?
Like if the report doesn't actually identify the.
No, like we can find out potentially that they've finished their report and they maybe have an idea who it is, but not necessarily that we will all know.
That would be a very John Roberts-y way to finish this, that he would see it as something that, we have reached a point where we are now satisfied with our investigation. Thank you very much, the end, rather than it was so-and-so in the office of such and such.
I guess also my other separate question is, I help cover Congress for ABC, and whenever there's a vacancy in the court and names are put out there, you often try to reach out to people, people who went to law school and some of these candidates, that sort of thing. How useful is that? I guess to either of you, did either spend time sourcing up around sort of the concentric circles around the justices, so not necessarily just people who work with them, but those larger networks? Is that useful once these people are on the court, or is it, once you're at that level, they're very careful about, keeping their work at work, and you don't get much out of these other relationships the way you maybe would with a politician?
Yeah, you can just sort of lower your expectations, like if you're covering Congress, like in terms of getting information and hidden details, and it's just not the same. But yeah, in terms of the candidacies, yeah, of course, talking to all sorts of people, and it doesn't necessarily lead to them having some sort of in the chamber in the chambers that it becomes. So.
And this, I don't think this was your question, but we didn't address it, so maybe we should. The whole process of nominations and confirmations is very different from anything we've discussed today. And that's wide open, and that's more politics than the law. And any number of ways to, work sources to find out, who's in the running, who isn't in the running. White House counsel's office, any number of people are in the loop there who don't have anywhere near or really any ethical problem with being a leaker. So that's a whole other game when you have nominations and confirmations.
I'm also thinking about, was it a book about Kennedy that came out recently, where there was something from his journal about a meeting he had with Alito?
Oh, Ted Kennedy. I thought you were talking about Anthony Kennedy.
No. It was a book about Ted Kennedy.
Yeah.
During the nomination,
It said that, I didn't put a lot of stock in this, because here's what it was. Kennedy is dead and gone, and it said that his diary, so he's speaking to a piece of paper, said that Alito kind of inferred or promised or made it clear that he respected Roe as precedent. And the story got, the headline became, Alito lied to Kennedy, and I think there's probably more nuance in that. You know what I mean? It's like Kennedy heard, well, and also Kennedy probably heard what he wanted to hear. It's kind of like the senator from Maine, Susan Collins, heard what she wanted to hear from Kavanaugh, but if you were a fly on the wall, maybe she,
But also confirmation hearings have become decreasingly useful. Like the nominees are able to sort of skirt questions and basically say nothing. So they're becoming less and less, I think, useful to pretty much anyone, to be honest.